But of course, if more money is poured, then under the Act, there are provisions by which the financial institutions will have directors over in the securitization company to manage the affairs of the company. But that's another concern that I'm flagging, which the Honorable Minister may well consider. Then the other company is called the Reconstruction Company. Again, apart from security, you will reconstruct the company. It's like the BIFR, Board of Industrial and Financial Reconstruction, except that this is now in private hands. What is happening, sir, is that in the era of globalization, public debt is also sought to be privatized. We are in that era of liberalization and globalization. We have seen that governments and financial institutions and banks are not able to recover their debts, and they get involved in court procedures which are tardy, which are lengthy, and which make it impossible for them to recover their debts. So they say, all right, let us set up a procedure in the era of globalization to give the recovery processes in the hands of the private sector. So this legislation is really a privatization of the recovery of the debt, because this government believes that every process of privatization is better than giving authority to the public institutions, and in the context of that, they are privatizing the debt, which is fine. We have no problems with that. But we want to beseech the government to ensure that this process of privatization and this process of recovery of monies, of reconstruction of companies, of securitization of the asset is effective, is efficient, and that more public sector money and more money from the banks is not poured back into these very assets to multiply the already non-performing assets and the quantum of those assets. With these words, sir, thank you very much.
Resolution moved. Shri Jaswant Singh ji to move a motion for consideration of the securitization and reconstruction of financial assets and enforcement of security interest bill 2002.
Mr. Vice Chairman, sir, honorable members are no doubt aware that our banking industry has to increasingly comply with international prudential norms and accounting practices. There remain, however, certain areas in which the banking and financial sector need to take further actions. Until recently, there was no legal provision for facilitating securitization of financial assets so as to generate immediate liquidity. Indian banks, unlike banks in some really several other countries, had no powers to enforce securities except by going through time-consuming judicial processes. Our legal systems, when dealing with commercial transactions, are not yet in pace with a rapidly transforming commercial environment. This results in asset liability mismatch as well as mounting levels of non-performing assets in banks and in financial institutions. It is to overcome these problems that the Securitization and Reconstruction and Financial Assets and Enforcement of Security Interest Ordinance 2002 was promulgated on 21st of June. This ordinance enables banks and financial institutions to realize long-term assets, manage problems of liquidity, asset liability mismatch, and improve recovery by exercising powers to enforce the securities easily. Copies of this ordinance were placed on the table of the House. The bill to replace the ordinance was introduced in the Lok Sabha on 19 July. Notice for consideration of the bill was also given on 19 July. Regrettably, however, the bill could not be taken up for consideration by the Lok Sabha. In the meantime, Lok Sabha was adjourned sine die. The ordinance was therefore re-promulgated on 21 August to save the actions already taken by banks and financial institutions under it. It is now proposed to replace that ordinance by the Securitization and Reconstruction of Financial Assets and Enforcement Security Interest Bill 2002, which has exactly the same features as the ordinance. Mr. Vice Chairman, sir, the Lok Sabha has already given its assent. As though I will subsequently be dealing with the issues that have been raised by the motion of disapproval that has been moved by Honorable Speaker, let me at this juncture refer to a somewhat broader issue which has been raised with me by several other members and with the highest intentions in their mind. It is possible, sir, that there be apprehensions about the applications of these provisions either becoming too stringent in application or being applied in such a fashion as to cause greater distress than as present exists. I wish to assure the House that the government is conscious of this and that it shall not let it happen. That is why I have already, when I got this responsibility of the Finance Ministry, I initiated action for what I have said elsewhere, including in that House, of a lender's responsibility bill. I am very happy to share with the House, sir, that just as it is necessary for borrowers to behave responsibly, it is our view that it is also necessary for lenders to conduct themselves responsibly towards borrowers and to meet their genuine requirements adequately and on time. That is why, in advance of preparing for such a legislation, I had constituted a working group to study the lenders' liability provisions obtaining in other countries, including in the United States of America, and to make suitable recommendations for our country. This group, I am happy to inform the House, has already recommended the introduction of a fair practice code as a starting point and as the first step towards the introduction of a lender's responsibility bill, which fair practice code is for banks and financial institutions. The RBI has already been given this fair practice code. It has been prepared in consultation with the Reserve Bank of India, and the Reserve Bank shall shortly be issuing instructions in this regard. In addition, sir, based on the experience that we gained, and I do not wish to go into the details of some of these fair practices, though I have no difficulty in enumerating them here, if you so desire or if anybody so desires. But these fair practices will provide us with the requisite experience to prepare a suitable lender's responsibility bill, which I assure the House I will come to the House with, and the House can then share its wisdom with us so that the apprehensions that honourable members have about the application of this particular ordinance and bill, they must be fully set at rest. So that is a responsibility that as government we have not only to the House but to the borrowers also. I wish to say this, sir, because this is an aspect that must be borne in mind, and we are aware of this and we shall adequately take care of it. With these words, sir, I commend that the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Bill 2002, as passed by the Lok Sabha, be taken up for consideration by the House.
Sir, will the lender's responsibility will be brought to the same route of ordinance, or it will be brought to the House?
I couldn't hear that.
Sir, the bill which you have referred just now, which you want to present before the House, the lender's responsibility bill which you are talking about, we hope that this will not be also through an ordinance route, it will be passed to the House.
No, I understand the honourable member's concern about the ordinance route. But I also understand that in asking the query, the honorable member is less, wishes to make a statement that in this ordinance route. No, I assure you, we will come forward with the bill so that you can certainly send it to the standing committee. Though here I must take an opportunity to share with the honorable members exactly the same concern that I had shared with the other house. I had, when I was a member of the other house, the standing committee system was introduced then. And if I recollect right, it was the 9th Lok Sabha that we did it. It is also a fact of life, sir, that matters referred to standing committee have now remained with standing committee, some of the measures, for as long as 24 months, which really rather defeats the purpose of referring issues to the standing committee. I recognize otherwise what has been said. The lender's responsibility bill shall be a bill, and we will, when ready and appropriate, come forward with it to the House.
Mention. I give you one example of the of proceedings of the select committee regarding the money laundering bill, the report of which was furnished to the government, I think, almost 1.5 years ago. And that bill has not seen the light of the day till today.
He can
so
reply.
whereas there may be bills which are pending before the standing committee, but there are bills pending with this government for more than 2 years which have not been brought to this house.
So he will reply.
I just want to place that on record. That please don't blame the standing committees. The government itself does not bring bills to this house, and it should do so, especially bills which have been cleared by standing committees and are pending with the government.
At the time of the replying to the debate, he will reply your question. Motion moved. The statutory resolution and the motion for consideration of the bill are now open for discussion. Shri Prithviraj Chauhan, Shri Ashwini Kumar.
Sir, it is indeed a privilege to be able to participate in a debate on what I consider to be a legislative measure of vast importance and crucial significance for the financial health of our economy and for the competitiveness of our industry as a whole. So the bill is long overdue. The genesis of this bill could be traced first to the recommendations of the Rajya Committee, then to the Narasimhan Committee's second report, and then to the recommendations of Mr. Andharajana, the former Solicitor General of India, and the two internal committees of the Reserve Bank constituted to look into the matter and scrutinize the proposals which are now before this august House. Sir, it does not require too much conviction to support in principle the measure that seeks to address a malaise that seriously threatens the entire economy of this country. Some figures were read out a little before to this House. I have a set of figures which I would only like to share with this House, only to underscore why this legislation is long overdue and necessarily must have, in my respectful submission, a bias in favor of the creditors. So today we have a situation where we are faced with a total non-performing asset portfolio of about 83,000 crores, and if stressed assets were to be added to this figure, it would go up to about 110,000 crores, and according to one estimate of Ernst & Young study, it might reach as much as 130 to 150,000 crores. So as against 2% of NPAs in developed countries, we have a situation where we have about 6.74% of NPAs, a situation totally and completely unacceptable and unsustainable. So therefore, in a spirit of constructive cooperation promised to the government by my leader and by the leader of the opposition, Mrs. Sonia Gandhi, I rise to support in principle the legislative measure that has been introduced. I have, of course, a number of points which I wish to make, primarily with a view to ensuring that the few loopholes that have been left unaddressed in the bill might in the long run have the effect of diluting the efficacy of the legislative measure. Sir, I have in mind certain provisions, but before I take the House to those provisions, I would like to express myself on the point of apprehensions regarding the possibility of the abuse of certain provisions of the bill. So whenever we conceive and implement a legislative measure, those of us who have some experience in the practice of law at the bar know that despite the best of intentions, a good legislative measure can fall by the wayside if the gaps in its implementation are left unaddressed. Sir, I know that there are provisions in Chapter 3 which to some might appear to be a bit harsh, and I am not oblivious of the concerns expressed by leading chambers of commerce in this country. But I also have before me a trite comment by the Chief Economic Advisor of CII, Onkar Goswami, who in his report said, and I quote him, sir, he said, and I fully agree with this, he said, there are sick companies, there are sick banks and unpaid workers, but there are hardly any sick promoters. This, sir, is a pointer to some of the undeniable reasons for the mounting NPAs in this country. There are, of course, external factors. There are, of course, factors on which we have no control, but they are very much internal factors which lead sometimes to manipulated NPAs, the siphoning off of funds, the diversification of funds. And sir, today the banks annually in this country are losing about 5,000 crores in interest income alone. All of this ultimately impacts upon the competitiveness of our economy, the health of our financial system, and also, sir, if I may say so, are the single most significant block towards lowering of the interest rate regime. And if you don't lower the interest rate regime, there is no way our economy can be competitive in the global arena. Therefore, sir, despite the fact that there is always a possibility of abuse of authority, and I would be the last person to deny that fact, but we also know, sir, those of us who practice law, that merely because of the possibility of perversion of law or abuse of power by an individual bent upon perverting the law, you do not question the validity of the legislation or indeed its justification. Therefore, sir, I would like to state that as far as the safeguards in the bill are concerned, I would like to point out that there are 5 or 6 important safeguards which do seek to assure all of us here that the possibility of the abuse could be addressed and reduced. And sir, these provisions are Section 13(2), 4, 8 and 9, Sections 17, 18 and 19, and in a short while, sir, I will within 5 minutes just take the House to these provisions. But sir, I am concerned about one provision about which I would specifically like to draw attention of the Honorable Finance Minister. So there is this provision that an appeal to the Debt Recovery Tribunal would not be heard unless at least 75% of the claimed amount is deposited. This is, sir, not an unusual provision. We have this provision even in respect of house tax. We have this provision in respect of income tax appeals. The quantum may vary. It could be 50% or 75%. And I would have no difficulty, and perhaps the Honorable Finance Minister may consider to perhaps reduce it to 60%, 50%, but that is subject to your discretion. But sir, I have a little concern. There is also a discretion to completely waive the deposit of the claimed amount. This is where my apprehension of selective application of the rigor of the law arises. Sir, if you are going to invest discretion to completely waive off the requirement of deposit, then I dare say the government could be open to the charge of deliberately letting in a window for people to escape the rigor of the law. And sir, I know that a rigorous law, when rigorously implemented, could be harsh. But in the very nature of this legislation, there has to be a bias in favor of the creditors. If you want this legislation to succeed, it must owe no apology to its harsh provisions, without which this legislation is meaningless. Sir, let it not be said that the present chose to pronounce against the future. We don't have the luxury of time, sir. This bill ought to have been introduced years ago. But sir, at the same time, as has been pointed out, and rightly so, laws are ultimately implemented by people, and all of us are fallible. Some are unconsciously fallible, some are consciously fallible, motivatedly fallible. And therefore, as we have assured this House, the law of lenders' responsibility is a sine qua non to introduce an element of justness and fairness in the implementation of the law. While we support the rigor of the law, we cannot but caution the government, let the measure not operate in a harsh manner. Let it not operate unjustly. Let it also, sir, not operate selectively. Let it not operate discriminatorily. Let it be operative with discernment, with humaneness, fairness, and justice of the cause will be best subserved if those who are invested with the responsibility, indeed the authority to implement it, are not only called to account severely when an aberration is brought to their notice, but are warned, are forewarned, are warned in advance that the slightest doubt in the integrity of the implementation of the law would likewise be called to account in as harsh a manner as those who willfully default in making good the payments of public debt owed to public institutions. Sir, one provision about which I need specifically to draw your attention to, sir, is 1313, sir. Section 1313, which I think is extremely important in the sense that, sir, before 13, section 9, if you don't mind, so section 9. So section 9 starts with the words, it says, without prejudice to the provisions contained in any other law for the time being in force, a securitization company or reconstruction company may, for the purposes of asset reconstruction and having regard to the guidelines framed by the Reserve Bank in this behalf, provide for any or more of the following measures, namely. So my apprehension as a lawyer is that this being a special legislation ought to prevail over all other general or incidental or related legislations. Now, if you are going to say this is without prejudice to the provisions contained, a serious question of conflict between the provisions of this legislation and other legislations is bound to open the doors of litigation in a very, very destructive manner. I think it must begin with a non-obstant clause stating, notwithstanding anything contained in any other law, the provisions of this bill must apply. Because if this bill, in the domain of its operation, is intended to overrule other legislation which are existing and found not to be efficient enough to subserve the policy objectives, then this legislation needs to be given an overriding effect. And likewise, sir, similarly, there are many provisions which, in my respectful submission, might dilute or give a window in a manner which I suspect is not envisaged or conceptualized in the legislation or conceived by its framers. Sir, the right to appeal is not, 2 minutes, sir, 2 minutes and I'm done. The right to appeal, sir, is not illusory. There is a right to appeal. Yes, it is a conditional right, conditional upon the deposit of an amount. But, sir, 8 months are given, 6 months before a default converts itself into a non-performing asset, and I understand in 2003 the international prudential norms are going to be applied, and this period might be reduced to 90 days. Thereafter, 2 months. Now, 6 months and 2 months, 8 months are a good enough window to those who have to pay up to come up and pay. And there's also a provision that if you pay up 75% or if you pay up before the auction or before the sale, the coercive steps will not be taken. So I think that's there. However, as I said, if in an appropriate case, a perversion is brought to the notice of those charged with the manner of implementation, let that representation be considered in all seriousness, not necessarily with a bias against whom the law is intended to apply, but with a view to affording a reasonable opportunity. That, sir, would add to the justness of the law and the justice of the cause. With these words, sir, I think I've made a point in principle. The Congress party supports the legislative measure. We have drawn your attention to some of our concerns only with a view to ensure that the efficacy of the legislation is further enhanced and not diluted. Sir, I had made certain suggestions even in my letter to you. There are certain matters of detail. For example, sir, in 14(1)(b) there are references to the forward movement, that you must forward a particular security to so and so. That word forward will need to be substituted by handing over of possession, because if immovable property cannot be forwarded, it has to be handed over. So there are certain matters of draftsmanship, and with your permission, sir, I would like later to perhaps put them on a piece of paper and send them on to you, because I do not want to detain the House any longer. I'm deeply grateful to you, Mr. Chairman, sir, for giving me this opportunity, and deeply grateful to the Leader of the Opposition, Dr. Manmohan Singh, to give me an opportunity to speak on behalf of the Congress Party. Thank you very much, sir.
Thank you, Ashwini Kumar ji. Shri Arun Jaitley.
Sir, I rise to support this bill which has been moved by the Honorable Finance Minister. In fact, I must compliment the Finance Minister and his ministry for having brought about this law, because this is already belated. I say it is belated because we've had different experiments as to how banks and financial institutions must try and recover their monies from defaulting debtors. We had till about 10-12 years ago the system where banks and financial institutions had to stand in the queue before courts like an ordinary litigant and make an attempt to recover their dues. The system did not work well. And thereafter, in the year 1993, the then Finance Minister had introduced the Recovery of Debts Due to Banks and Financial Institutions Act 1993, which provided for setting up of the debt recovery tribunals, where any claim more than 10 lakhs, the banks and financial institutions had to go and file an action before those tribunals. Now, for the last 9 years, we've also seen the functioning of those tribunals itself. Additionally, sir, we had attempted through the SICA Act also a procedure for rehabilitation of the SIC units, which was brought about in the year 1985. And today, in the year 2002, we stand confronted with a situation where the situation, despite the 1993 Act, despite the SICA Act, doesn't appear to have improved. I attempted to collect certain figures which have been referred to both by Mr. Sibbal and Mr. Ashwini Kumar in very useful comments that they have made on this bill. The situation, in fact, today is a little worse than is evident from what their figures are. Before the debt recovery tribunals, where we thought there would be an expeditious methodology, where instead of moving to courts, you move to a tribunal, and tribunal not being bound by judicial procedures, but only being bound by the principles of natural justice would expedite. We also thought that the recovery mechanisms would be much faster. And in the year 2002, we have a situation where before the debt recovery tribunals, a total number of cases which have been filed by banks and financial institutions as on 31st of March 2002 is 56,988. The total claims which have been struck in these tribunals as a result of these claim petitions is 1,08,665 crores, close to 1,10,000 crores. That's approximately 1/4 of what the national budget is. What we have managed to recover in the last 9 years, as against these 1,08,665 crores, in terms of decrease on paper. Why I say decrease on paper? Because values of assets depletes, assets have been squandered away by defaulters. So what decrease have been obtained as against these 1,08,000 odd crores is only 18,556 crores, which are decrease on paper. The actual recovery of money against claims of 1,08,065 crores is only 4,737 crores. So when Mr. Sibbal was speaking in terms of now thinking of alternate routes, rather than the route through the courts or through the tribunals, which is judicial intervention, I'm sure he was seized of this gloomy picture where banks and financial institutions have claimed to the extent of 1,08,065 crores, 665 crores. What they've actually recovered is something close to only 4% of what is the actual amount due to these banks and financial institutions. This itself, sir, tells a complete tale of how we have now to think in terms of alternative strategies, how to devise this, and how to make sure that the banks and financial institutions are able to get their monies back. Because if we do not do that, enterprise, business, commercial activity, which is to be funded by the banking sector, by the financial institutions, will itself be in a great difficulty, because banks, instead of funding business, instead of helping sick businesses to revive, are themselves going to feel the brunt of sickness themselves. That seems to be the system, and I think we must very honestly confess that judicial intervention in these matters has not been helpful at all. On the contrary, judicial procedures have provided roadblocks, and they have become a big hurdle in the manner of banks and financial institutions recovering their money. Then, sir, in 1985, we considered the system of 1985 of how to revive these sick industrial companies where these monies were struck. Most of the NPAs were blocked in a large number of these companies. So we devised the 1985 legislation, which we call the Sick Industries Act, the SICA Act. The SICA Act, I believe, was conceptually a defective model. It was a defective model for the reason that the jurisdiction of the BIFR used to be invoked after the net worth of a company became negative. That is, the liabilities and its losses were more than its assets and reserves. So when the net worth itself was negative, the company was already a sick company, it was already in the doldrums, it was a company which was suffering from 4th stage of cancer. We then decided to have that company treated by suggesting that it gets into the BIFR. The entry point into the BIFR was sickness, and sickness was negative net worth itself. By that time, it was extremely difficult to revive these companies. We then had a provision in the Act itself, which became a great setback for banks and financial institutions, for workmen, and also for other creditors, that the moment the company sought entry into the BIFR, an iron curtain by way of Section 22 enclosed it, and nobody could institute an action, not even workers, to get their dues from that company. As a result of which, banks, financial institutions, secured creditors, unsecured creditors, revenue departments, workmen were all being deprived of their dues. The procedures for developing the schemes itself are extremely slow. And when winding up was suggested, We in India have a procedure for winding up through the institution of an official liquidator, in which case I think we have a number of people here who are associated with the various courts and laws in different ways, who would probably vouch for this, that through the process of winding up that we have developed, recovering monies through winding up of these companies for the creditors itself has been a process which has not succeeded in this country. We today, as far as the BIFR is concerned, sir, have a situation where till last year, I am referring to the period ending 31st October 2001, how BIFR has been misused. We had a total number of 5,059 references, of which 1,293 were declined on the first day itself because they were just devices to get into the BIFR to make sure that the creditors are denied their dues. 792 were held not maintainable after a hearing. So almost 2,085 were not maintainable. And in the last 15, 17 years that this law has been enforced, the total number of companies which actually got out of sickness were only 292. Out of 5,059 which approached, this mechanism that we developed in 1985, which seriously requires a reconsideration, only 292 have been able to revive out of the sickness. The other were either misused, references were not maintainable, or which are pending for years. And the number of pendency, if we look at it, since 1987, there are even today in the last 15 years, 22 references which are still pending. This was an expeditious methodology of revival of companies. Since 1988, 12 are pending. Since 1989, 19 are pending. And as of today, 1,508 are pending. And therefore, this mechanism itself has not succeeded. Of these companies which are pending there, which we are trying to revive out of their sickness, and these are at the end of the day, whether in the private sector or the state sector, these are national assets. These may be monies of banks, these may be monies of financial institutions, these may be monies of investors, these may be dues of workers, these may be dues of revenue. These are all monies of, these are national assets which are lying blocked. The net worth of these companies, which is pending there, is about 2,30,000 crores. But their accrued losses are something close to 4 lakh crores. That's 3,88,000 crores. This then, sir, is the methodology by which we are today locked in a situation where how do banks and financial institutions, which are to revive the economy by lending money, by investments, who themselves are confronted with a situation that they've lent their monies, and today they have actually in the last 9 years, through the existing mechanism, being able to get back only 4% of it, except those honorable creditors, debtors who are actually honorably paying the banks and financial institutions back. There is also a dispute about what is the figure of NPAs in this country. Mr. Sibal mentioned a figure of something close to 56,000 crores. Now,
77,000. Banks and financial institutions, 77,000 crores.
well, it appears to be that banks in the public sector, you were right when you said it's about 56,000 crores. Financial institutions, you were right when you said it's about 27,000 crores. But then these are only banks and financial institutions that we perceive to be either in the public sector or under the ownership of the people, directly or indirectly. You have old private sector banks, you have new private sector banks, you have foreign banks, you have public sector banks, you have financial institutions, and if you total up the NPAs of each one of these, the figure today comes very close to what Mr. Ashwini Kumar had mentioned, a staggering 98,061 crores. And when we are dealing with this particular law, this is a law which cuts across, which deals with banks, private sector banks, financial institutions, all financial institutions of this kind. So the NPAs are reaching this staggering figure of 98,061 crores. And that is why the government has seriously been seized. It's not only this government, it's for the last several years. You had the Narsimhan Committee 1, you had the Narsimhan Committee 2, you had the Andharujina Committee. And therefore now you've had a situation where, if I understand as to what really seems to be happening in this sector, is the creditors are chasing the debtors. The banks are chasing the defaulters. The financial institutions are chasing the NPAs. And those people can broadly not be touched. in a number of cases,
And the defaulters are chasing the politicians.
well, I was almost tempted to say, but
I just, in the lighter vein, in a lighter vein.
in an equally lighter vein, I hope it's not the other way around.
I don't know.
The politicians start chasing the defaulters.
I agree.
So you have a situation where the creditors are chasing the debtors on their knees, please give me my monies back. Has the time now come? And this particular law seeks to reverse the principle. Some have called it harsh. But then a legislation has to really have nexus to what is the ground reality. Do we now reverse this relationship and make sure that the debtors start chasing the creditors and start repaying the financial institutions? In fact, the experience lately has been that after this ordinance was promulgated, a number of people who had otherwise just turned their backs to financial institutions and banks, an extraordinarily large number of them have started coming to the banks and financial institutions, presenting schemes for settlement, starting to pay installments, and money has not started exactly flowing in, but certainly started trickling in. Barring a few cases, offers are now being made for settlement because those people also know that wherever their money is lying hidden, if the money is not paid, their assets are going to be physically taken over, not through judicial intervention. If their houses have been mortgaged, the banks don't have to wait for the next 10 years before they get a decree and the next 10 years before the appeal is decided. Their houses are going to be taken possession of, these gentlemen are going to be on the roads. And therefore, debtors are now chasing the creditors and pleading with them because of a new legal regime which is being created and asking for a settlement. The second consequence which this law seeks to avert, sir, is that banks and financial institutions which would be rendered themselves sick because there is no efficacious mechanism for recoveries of their monies back, are now in a position to at least get their monies or some proportion of that money by taking over those assets and selling those assets. The defaulters who enjoyed a legal regime that they could indefinitely delay the proceedings through judicial mechanism, that facility now has been taken away. And lastly, values of all secured assets, mortgage assets, which has depleted. In the last 7-8 years, there has been a fall in real estate prices all over the country. Therefore, even when banks legitimately at the time of giving loans took securities, they are today confronted with a situation that the actual value of those securities has been depleted because the value of real estate in this country has gone down. And therefore, if they have to wait for the next 10 years before they can go through a court and then take possession of the asset and sell the asset, the values go down. This handicap, the banks and financial institutions will not be confronted with. So one criticism of this bill that I have read in newspapers, in fact, Mr. Sibal, while supporting this bill, I can't say that was a criticism. He made this suggestion at the very outset that we are now thinking of a new legal system whereby we avoid a judicial intervention. Let me say this is not the first time that this has happened in this country. We had existing models available where we were avoiding judicial intervention and creditors, both private and financial institutions, were entitled to take over their assets. For instance, the State Financial Corporations Act. Every state has a financial corporation that gives monies to various private sectors and small industries. When there is a default under section 29 of that act, even without judicial intervention, there is a power available with the financial institution to go and take over the assets. This is a time-tested mechanism on basis of which SFCs have worked. You had the Small Industries Reconstruction, Industrial and Reconstruction Bank of India, which is still in operation. There is an identical provision without judicial intervention to go there and take over these assets. You have the IRBI Act, which had a similar provision. Even under the Contract Act, section 172 to 176, which deals with pawns. If there is a default, you can sell the asset without a judicial intervention. English mortgage, which is provided for in the Transfer of Property Act, without judicial intervention, you can go and enforce the English mortgage, though only a limited section of Indian population is entitled to its benefit. Bank guarantees. Enforcement of bank guarantees, their encashment, doesn't take place through a judicial intervention, But the moment the person in whose favor the guarantee is issued is satisfied, a default has occurred, he can go and enforce the bank guarantee and collect the money. These are all procedures which have been upheld under our existing rule of law. The only question is, so far, even when most of our banks were in the public sector, now of course a large number of them in the private sector have also come up, this facility which is something which we were denying to them.
In the legislations that you have mentioned, and this particular legislation is the following, that whereas in all other legislations the creditor had the right to sell off the asset and through a particular procedure, here the creditor has the right, pending everything, to dispose of the asset to a third party. He gets a clean and clear title, and that cannot be the subject matter of any dispute, and that cannot be questioned. That particular provision is not there in all the previous legislations. That's the only difference. The rest you are right.
Sir, I don't exactly wish to join issue with my learned friend, but under this act also and the rules which have been framed under this act, under this ordinance so far, it's still not to become an act, there is already some safeguards which have been introduced, and I'll just refer to some of those safeguards. You have therefore four broad features as far as this legislation is concerned. There is a securitization of financial assets. There is a setting up of a central registry for registration of those security interests. There is enforcement of those security interests. And there is a provision with regard to asset reconstruction. These are the four broad features as far as this law is concerned. Now, if we just take section 13, which is actually the soul of this legislation, if I may say so, without which this legislation would not be efficacious. You first have a provision that a bank or a financial institution which has lent money for the loan to become a non-performing asset. Under the scheme today, it becomes a non-performing asset if for 180 days there is no payment of installments. Under the changes which are proposed, this 180 days is intended to be made into 90 days. That's correct. After this 90 days period, there is a provision for a 2-month notice. So you tell the defaulter that you are in default for 180 days, which will become 90 days. You have not paid back the installments, and therefore we are issuing you a statutory notice that we will take action against you. Before you take action under the section, one bank or one financial institution cannot just stand up straight away and take action. 75% of the secured creditors must agree to take that action. That itself is a safeguard. We can understand where large borrowings are there, where people are defaulters to the extent of a few 100 crores or few 1,000 crores. There are a number of banks and financial institutions which are involved in the funding of that project. So all of them have to get together, and till 75% of them agree. There may be cases where people may well feel that this is a running concern, just that it had a bad cycle, there was a default, we decide to give them some opportunity, we restructure the loans. But there may be cases where they feel that everything is being written off, then 75% of them must agree. They will then take over possession and send under section 13(4). Mr. Sibbal is very right when he says that till the stage of section 13(4), when the notice is issued, the defaulter has no remedy. Because if a remedy were to be provided to the defaulter, merely because he is in default for 180 days, merely because on a 2-month notice has been issued to him, if now he starts going to court and taking anticipatory stays, preventive injunctions, then the whole act will itself, the operation will come to a standstill. The first remedy which has been given to him is, the moment possession is taken over, under section 13(4), if he feels that there is a case of vindictiveness, there is a case of unfairness, a right to appeal, a full-fledged right to appeal, on every question of law, on every question of fact has been provided to him. He can go to the Debt Recovery Tribunal and file an appeal. Sir, what happens in this process is, the one change which I mentioned, as of today, creditors are chasing the debtors. The moment his property comes into the hands of the creditor, it is he who is going to run and file appeals and say, give me my property back, I am on my knees, I am prepared to pay you something. The debtors will then start chasing the creditors. It is this reversal that this law seeks to bring about. Not only this, a right to second appeal. It's virtually a second appeal under section 18 from the Debt Recovery Tribunal, which is also available to him.
This appeal and second appeal are both through a judicial tribunal. The appeal tribunals all over the country, I understand there are some more than 27 of them, are headed by officers of the level of district judges. The second appeal tribunal are headed by retired high court judges in 4 different zones of the country. So judicial authorities are going to hear the appeals. It was pointed out, and I thought there were some different suggestions which were made by Mr. Sibbal and Mr. Ashwani Kumar with regard to the mandatory deposit of money at the time of filing an appeal. In fact, these are two, if not conflicting, two different views which were expressed by both of them. Now, deposit of money at the time of filing the appeal is not something peculiar to this Act. The 1993 law, which provided for setting up of debt recovery tribunals, has an identical provision. When you file the appeal, deposit 75% of the money. But if you have a very strong case and you convince the judge that this money is not owed to you by you, then he has the power to waive off. He can bring 75 down to 50, to 40, or even to 0. That power has been given to the judicial authority. There is no need to dilute that power in any case. In fact, here the amount mentioned is 75%. In most other legislations, in your Customs Act, in your Excise law, when demands are made after adjudication orders, 100% of the deposits have to be made. And these are time-tested provisions. In most municipal laws, when municipalities are starved of funds for property tax or other demands of municipalities, the law is that 100% of the deposit must be made. And there is a power given in most acts to the judicial authority that if he feels there are special reasons, he can waive off any or all of the amount. In fact, one of the only acts where there is no such power is the Bombay Municipal Act. Mr. Murli Devra must have come out with it. There is no power of waiver at all. So if you have to file an appeal, you must deposit 100% of the money, and there is absolutely no discretion to waive that amount. And trend in economic legislation has been, in revenue legislation has been, that you must, in order to make an appeal conditional, provide for, you can't have the facility of filing appeal after appeal and not pay any money. You must pay some deposit, and that amount of deposit will not be judged by the bank, but will be judged by the judicial authority after a prima facie view whether monies are payable or not payable. In addition to this, there is a very important provision in this Act, Section 19, because both the learned speakers who spoke before me mentioned that there must be no arbitrariness. You can't pick and choose. Well, this will be done on some sound commercial considerations. Banks and financial institutions may feel that a particular project or a particular industrial undertaking is such that it has a bright future, it's just going through a low phase, it may restructure the loan. They may feel that here is somebody who's siphoning of the money and we must immediately enter and take over the assets. But if they use this power in a mala fide manner, Section 19 provides that if it is wrongfully taken, this possession, if this possession is wrongfully taken for vindictive reasons or some other reasons, the banks on the direction of the appeal tribunal will have to pay compensation to the person from whom possession has been wrongfully taken up. There is already a provision which provides for this. Mr. Sibbal made a point that when you take over possession of these assets, there must be no arbitrariness. You should not be allowed to sell at an understated value. There should be no collusion in the manner of creation of third-party rights. Because in such a situation, if an asset worth 50 crores is sold for 10 crores, the debtor loses, the creditor loses, and a third party benefits, and probably somebody unlawfully also benefits in the process. I'll only suggest to my learned friend that the rules which have been framed under this ordinance itself have now a specific provision with regard to valuation. After the asset is taken over, there is a provision for fixing the valuation, and it says, well, the Center Hotel example, Mr. Sibbal, now that you've re-raised it, may perhaps be a case of being not undervalued but ill-informed. And if you want me to deal straight with the Center Hotel example, since you've twice raised with it, let me now deal with it. Values of assets, I must tell you the principle. When privatization takes place and you sell shares at a particular value, what the value of shares in the market 6 months or 8 months later is going to be is not determinant of what the pre-disinvestment value should be. If you remember correctly, the government had disinvested VSNL. VSNL was disinvested at a value of 202 rupees a share. The market price 2 weeks ago was 92. The government had disinvested CMC. The value in the market was 6 months later was twice the amount. The government disinvested IBP. The IBP was disinvested at a value of rupees 230 per share. The value in the stock market now is 66. What values of disinvested shares 6 months later are or 1 year later are is no determinant of what the pre-disinvestment value should be. This is a fundamental.
You accept the fact that a 32 crore profit was...
I do not accept the fact.
I thought you were correcting me on the
I am
fact.
sorry, I do not accept the fact.
No,
I
no.
accept the fact that even on 32 crores,
No intervention, please.
even
Let
on
me speak.
32 crores you are ill-informed for the reason your 32 crores does not take into
Not
consideration
mine
the...
yet, somebody else's.
Mr.
32.
Sibal,
Well,
let me speak, please.
since you have chosen to rely on somebody's borrowed wisdom, let me correct you. Your 32 crores does not take into consideration the 7 crore of stamp duty. Your 32 crores does not take into the account the 6-8 months that the private party ran it, the interest factor, the cleaning of the balance sheet, these investments into the company itself in terms of additions.
But if he wants to do that, then he's opening another debate.
Your turn will come.
No, it is not
Your
like that.
name
My
is here.
term only 13 minutes for such a big thing. You bring an the government brings an ordinance,
You-
so many clauses. My term is 13 minutes.
Well-
He brings in a clause of
Well, you should have-
disinvestment and
Mr.
justifies this.
Well, my
This is
friend
the
then
way-
should have
Mr.
stopped
Mukherjee.
Mr. Sibal from
He is
starting
going
the
to
center
evaluate the
debate.
assets.
He has
And
started
if
it and
as
therefore
a
I
Mr.
will try to
Mukherjee,
answer it.
please sit down.
I chat.
Yeah.
This is the way he's
Your-
going to
your
justify.
name is here.
The asset reconstruction companies will be forced.
Please sit
This is
down. Your
another
name is
point.
here. Your name is here. Your turn will come. Your turn will come. Please. Hi. Yes, please
Sir.
go on.
Sir,
Mr. Jivaloy, please
Sir.
don't disturb.
I had no intention of joining issue on a Centaur Hotel issue, but since it was twice raised, I thought something had to be said on the issue.
You,
I have cleared the confusion I thought on Centaur
Mr.
Hotel.
Mr.
He's a member speaking on this bill.
Yes, yes.
If there's a charge against the government, it is the government who will, like the minister. will-
You will say, when your, Mr. Mukherjee, please, please. No, listen.
He's a member, he's speaking as a member or a former minister or a minister. There is some point.
Sir, is my right as a member sought to be curtailed?
He is
If I
honorable
want to
member.
contest a figure, some
Mr. Jaitley, please, please.
Sir.
Mr. Mukherjee, sit down, please, sit down.
काहे को फालतू
Yes,
में
Mr. Jaitley,
Sir,
continue.
Mr. Ashwini Kumar
Yes.
had
Continue.
raised a very important question with regard to conflict with other laws that this may arise. Section 31 of this ordinance clarifies the law that this ordinance does not apply to a large number of transactions. At the same time, it does not bar the application of several other laws under section 37. There are only some laws which are barred, and that also has been clarified not by one but by two provisions of this act. So there is only one suggestion that I have to make to the Honorable Finance Minister, and that is in relation to section 13(2), when it speaks in terms of taking over the management of secured assets of a borrower. Whether in the subsequent rules or the guidelines which are framed, or even under the RBI guidelines, this point may be incorporated. What is mentioned on the scheme of this ordinance itself, which we hope will become an act, that there is a 180-day period for it to become an NPA. There is then a provision for a 2-month notice, that is a 8-month period. There are a large number of very small borrowings, particularly in the automobile purchases, household item purchases. In industrial corporations, in large number of companies, is 6 months and 2 months may be a reasonable period. But in a number of small borrowings, this may itself become a very unreasonable period when the defaults take place. Therefore, when RBI guidelines are framed, at least in relation to this, the existing regime which continues, which is governed by the contract itself, may continue, or some provision may be conceived in those guidelines itself, Otherwise, recovery of those loans, which is otherwise expeditiously proceeding, may get unusually delayed. With these words, sir, I support this bill before this Honourable House.
Thank you very much, Mr.
Honorable
Jaitley.
Chairman, sir.
Shri C. Ramachandra.
Honorable Chairman, sir, I have one simple question, half a minute only,
To whom?
with your permission.
Nay, to whom?
To my respected Jaitley.
No, you cannot ask question from a member. You can ask from the minister. Please. Not from Mr.
Thank you, sir.
Mr. Ramachandra. Mr. Ramachandra.
Sir, I am trying to get this.
He has finished his speech.
Sir, thank you, sir. I rise to start the supporting the securities and the reconstruction of financial assets and enforcement of security interest of 2002. Sir, it's really a matter of grave concern about the NPAs that are prevailing in this country. I had the privilege of talking on this subject umpteen number of times. And one should feel that it's not anymore the lender's problem. It is equally a borrower's problem. Sir, this banking credit or credit from financial institutions, it has played a very good role as a catalyst for developing the economy of this country. I really compliment the government for bringing this bill, which has been inordinately delayed. This will facilitate the commercial banks and the institutions to repossess the assets, to realize their debts without going through the process of the law. That is the greatest positive feature of this bill. Sir, this right has already been conferred with state financial institutions, state financial corporations under Section 29. SFCs enjoy this right and they are successfully, they could able to reduce the NPS in the states. Sir, I heard the speeches of so many members in Lok Sabha also. Some members have suggested there that a criminal action has to be initiated against the officers of the banks, against the borrowers. Sir, there are willful defaulters, I do accept. But to what extent the system in this country, the philosophy of the economics that is responsible for this NPS also has to be taken into consideration. Sir, if you go through, virtually, it's not that I am supporting any NPS is posing a great concern, but it is considerably being reduced from 90 to 93. It was 23.18% gross in 90 to 93, it is 14% now. And, 23.18, now it is reduced to 12.4. And net 14.46 to 6.74. Sir, what I am trying to drive is, it's a very alarming picture, I do admit.